It's really my pleasure to introduce and welcome this final lecture in the Dean series on race and discrimination. As we all know all too well, and it's all too difficult to see the engagement that we need today with understanding the institutional structures that are perpetuating inequalities, injustice, brutality, and violence. Throughout this series, we have had the incredible privilege and opportunity to listen to some of the country's foremost scholars deliver their incredibly rich perspectives on racial justice, on discrimination, on the context that we're living through today. And we're incredibly fortunate and lucky to have Professor Shaw round out this series for us in his lecture, Education Rights. Professor Shaw is one of the country's leading scholars in the area of education and its impact on minority and underrepresented communities. He lectures widely and contributes powerfully to debates in relation to access to justice and access to education for minority communities, for migrants, for undocumented immigrants. He talks incredibly persuasively on affirmative action, on the role of HBCUs in state constitutional law, and under many, many other different topics. He is a leading light that contributes and combines interdisciplinary understandings of law, sociology, and brings quantitative methods to his research that have made him one of the leading scholars today. Professor Shaw is going to talk to us about a discipline and about a topic that is very close to us, an engagement that we are currently in, and that is very personal to our lives at present. So without further ado, I'd like to request and turn it over to Professor Shaw to give us his talk on education rights.
Thank you so much, Dean Yadav, for that very kind introduction. I always like to begin by thanking my team of research assistants, George Bouchard, John DeRazio, and Russell Wade at Washington and Lee, where I'm currently a scholar in residence, and Francisco Santelli at Peabody. Each of them is truly commendable and foundational to the work. And I think as we talk about education and justice, we need to think about how we assign credit and support to everyone who participates in the generation and the sharing of knowledge. So toward that, I hope you ask really challenging questions in the Zoom chat. I can be reached either at Twitter at Matt P. Shaw, that's MATTPSHAW with the hashtag education justice, or in the Zoom chat here, or later in a question and answer session. What I want us to think about today, and I know that we have a lot to think about, is what is education justice and what should education justice be? Every day we are presented with one racial aggression after another, whether it's police brutality, or poisoned water, whether it's food insecurity or housing instability. But I want you to think about all of these filtered through education justice, because all of this comes back to schools, and schools influence all of these. At the heart of the so-called American dream is a transcendent belief that one can overcome one's circumstances, even those imposed by external forces, through some combination of grit, merit, faith, and works. I'm not here to challenge the American dream today, or its narrative arc, or even to indict its prescriptive optimism as the wrong cure for structural racism. What I am here to do is to help ask questions that empower the transformation, the reformation, and when necessary, the eradication of educational institutions that stand firmly in the way of well-established constitutional, statutory, administrative, and practical obligations to education justice. And I hope that this group in particular, as law scholars, students, lawmakers, lawyers, citizens, and residents of the Republic, interrogate yourselves, as I hope I'm interrogating myself, to better understand how we cede the very transformative power we work so hard to acquire. We do not have education justice in the United States. It seems somewhat of a truism, but it bears repetition that we do not have education justice. In the Gary B. versus Snyder case out of Michigan, as recently as 2018, only 7% of Detroit public school students could read at grade level. That's 93% of DPS students who could not read, but yet were given credentials that said they were prepared to engage in our socioeconomy. In Flint, Michigan, 53% rise in the number of students who qualify for special education services since 2014, when Flint supplied its residents with lead-contaminated water. In New York City, we have, in the so-called melting pot, so-called magnet schools that have substantially low Black, Latina, Native, and even when you look at the breakdown, Asian and Pacific Islander representation. We've become wedded to this idea of the model minority myth, and beyond that, to meritocracy, even as we talk about how many of you are joining me on this talk today as students at Vanderbilt University. It's a deceptive and malignant lie that traps some students within an oppressive, never-ending testing regime. It offers its victims, and there are many, substantial opportunities to be evaluated, but substandard educational opportunities. And even the choices it offers those who allegedly benefit are tainted by the conversation on merit. And this isn't just in elementary or secondary education. The states continue defunding historically Black colleges and universities. In Tennessee right now, Tennessee State University, the state's only public HBCU, is fighting for funding to, at the very least, recapture what was lost by decades of underfunding, decades of mismanagement, decades of shifting programs away from Black colleges and from Black college students to pretty much everywhere but Tennessee State. So these created barriers upon barriers for Black students accessing higher education. And Black students continue to surmount those obstacles despite those odds. Recently, a colleague, Dominique Baker, a Peabody graduate at SMU, shared testimony about how the cost of college, any college, even Harvard, Yale, Vanderbilt, and Penn, has become unconscionably high. And that's for the students who somehow manage to survive high school, who manage to learn to read in systems that don't teach them, insist and persist to graduation, and make it through the remedial education courses many of them have to take because we have undereducated them. We see sharper divides than ever in our nation's public schools, and even sharper divides in our nation's higher education systems. We talk about students who placed in the top half of their class with a 0.13 GPA without indicting ourselves, without understanding how we have failed to offer basic rights guaranteed by the Constitution's due process, or anything remotely resembling equal protection. Even within our schools, you will see hallways where Black students go and hallways where chemistry labs are, and you don't see the two mixing. And despite the Individuals with Disabilities Education Act, the Americans with Disabilities Act, and sections 503 and 504 of the Rehabilitation Act, we do not have educational opportunities sufficient to meet the needs of all students with disabilities. We don't have adequate facilities or appropriate supports for disabled students. Instead, we bicker about whether a renovation is going to include 1 or 2 ramps, or whether we will have enough stadium seating on ground level classrooms so that everyone can access the education that allegedly we all pay for. And some were nowhere close to free and appropriate public education in the least restrictive environment as IDEA would prescribe. And we still actively discriminate on almost every categorical basis. Ever since 9/11, we've seen constantly on the verge of English-only laws, all of which would be found unconstitutional were they enacted, but we have never approached English language arts instruction, not to second language speakers or to first language speakers, commensurate with our enthusiasm for English-only laws. We talk a good game about STEAM, science, technology, engineering, arts, and mathematics, but we don't make those opportunities available to all students. One can't help but think of how many doctors, lawyers, scientists, sculptors, playwrights, actors, mathematicians we have lost by failure to invest. Our public schools are also not safe. I can't think of a week that has gone by where we haven't had a robust conversation about yet another school shooting, or whether we should have police in schools. But beyond that, they're not safe in terms of sexual violence or racial violence or discursive violence. But we have a very active ability to punish and humiliate students for their hair. We can punish them for their clothing. We can deny them food when they're hungry. We can make poverty a barrier that leads students to drop out of schools. We can shame them for their bodies. We can treat girls in ways that we would never imagine treating boys, students of color more harshly than white students, disabled students, often because of their disabilities. We are having an uncommonly awful focus on targeting LGBTQ students, particularly transgender students, because they are queer or trans. We rarely talk about migrant or refugee students or undocumented students, those in mixed residency status families, and we have all but forgotten students in our foster, juvenile, and incarceration systems. So almost 70 years after Brown versus Board of Education, children everywhere, and in each of the categories I mentioned, Black children above and beyond them, whether in urban, suburban, rural, desegregated, resegregated, charter magnet, open enrollment schools, just ain't being taught. And the question is, how does this happen? Allegedly, we won Brown versus Board of Education. But one of the things I want you to think about is, what did we actually win in Brown? Now, I'm not challenging that Brown versus Board of Education was a transformative moment for the United States, or that it was necessary. What I ask of you, particularly those of you all who are in law study, is that you think about what's in the Brown case and what isn't in the Brown case, what could have been in the Brown case and what we have to do to make the spirit of Brown letter. How does the same law that recognizes education as the most important function of state and local governments as the very foundation of good citizenship, the law that requires the state to make it available to all on equal terms, allow good and bad schools within a school district? How does this law have actually no teeth? How do we come to the point where discipline is allowed to run rampant, but teaching is curtailed? How can states say with no remorse or apology that young people whom the states have incarcerated do not have a right to public education? How is it lawful and irredeemable and unchallengeable? How is there no standing to challenge the miseducation of hundreds of thousands of students? The states compel their attendance at their own miseducation for at least 180 days a year, every year from near infancy to adulthood. What can we do about it is the challenge. So I write about what the federal government hasn't done, and I try to come up with creative solutions around it. Primarily, the federal government has never defined education. So here at Vanderbilt, we have a law school and we have a College of Education, both well-respected, but I'll submit that neither can actually have a conversation with each other, because we think we're talking about the same thing, and we're talking about really vastly different concepts. So in education, we often talk about teaching and learning. We talk about policies that encourage the teaching and learning, about making schools safe, psychologically, emotionally, socially. But in law, we talk about who has the right to make that decision. More or less, we've been living under a regime of local control, a Trojan horse of the segregation era standard from Plessy versus Ferguson that Justice Lewis Powell, whom I have been studying for the past year, promoted through his education doctrine from around 1973 to 1983. Local control is the most important concern that the federal courts have had in evaluating education decision-making since the 1970s, to the exclusion of almost all factors, including many I just named. So if you're looking at this from the appellate court view, which many people will do, is particularly those who have been trained or recently trained by law schools, you're looking at the United States Supreme Court, or you're looking at the Sixth Circuit if you're in Tennessee, or the 11th Circuit if you're in Georgia, or you're looking at the Fourth Circuit if you're in Virginia. I would submit that there are no votes in any of those circuits or the Supreme Court, not even if the court were to somehow be enlarged by the recent proposal by the Democratic Party in the Senate and the House You don't have the votes to undo local control. We also don't have the votes to declare education as a fundamental right. But what we have the opportunity to do in law is to define education. And if we have a robust definition of education, we can decontaminate and reshape local control or circumvent local control. I also submit that we do not need to call education a fundamental right to treat it as a fundamental right. Education can be foundational in many ways without that particular moniker. The fundamental right language tends to attach to things that are identifiable clearly in the Constitution, or by extension to certain liberties that have analogs to defined rights in the Constitution. We focused a lot of our energy in trying to make education fit neatly within those confines. And while there are strong arguments for education with respect to facilitating voting or facilitating participation in the socioeconomy, by limiting our conversation there, we have seen post San Antonio versus Rodriguez in 1973, the gradual, and I might now say exponentially, shrinking of an opportunity to find an education right that's protected in the US Constitution. So I'll say for now to put that to the side and not focus so much on getting that fundamental right label, but instead, let's reconceive what education is. And this is an opportunity for education scholars to communicate directly with law scholars, because this is an empirical question. This is not a question of feelings or even of jurisprudence. This is, what is education and how does it facilitate or not certain rights in the Constitution? What have states done in promising education? Have they promised something of substance and value? Or have they just said you just have to sit in a room for a certain number of hours a day for a certain number of days until you are of legal majority? So to end this first part of the talk, I want us to think about the idea that local control is not quite what it seems, and that we can define education and reshape local control toward accomplishing education justice. The recent education law cases, for those of you who are familiar, starts with Swan versus Charlotte Mecklenburg County. And that's the case that brought school busing to much of the country. It's also the case that really rattled the cages from a very clear deterministic pathway from Brown versus Board of Education, even through Brown 2, despite all deliberate speed, into a court that was committed to accomplishing educational desegregation. The idea being that educational desegregation would lead to greater opportunities for minoritized students who had not been allowed to participate in the bounty of what much of education had been. The reason it rattled the cages was it was desperately unpopular. It was unpopular among white families who responded by fleeing the public school systems, by devising many ways to segregate within systems. And it was desperately unpopular among Black families who bore most of the burden of their students sitting on buses and traveling for hours in order to go to classes in schools where they were not wanted, or who were constantly zoned over to the point where in a single year, a single student could be assigned to 3 different schools if that is what was deemed necessary to accomplish racial balancing. We have to talk about this unpopularity as creating the juggernaut of local control that we currently live with. And we have to also talk to educators about what local control actually is on the ground. Interestingly enough, you'll find very few teachers or principals who will go along, full stop, with an idea of divesting local control. The idea being that I know what's best in my classroom if I'm a teacher, or I know my students better than anyone in Washington, D.C. might, if I'm a principal or a superintendent, or even a governor. And there's a lot of purchase in that argument. But to the extent that local control has allowed states to not invest in certain school districts, or districts to invest differently in schools within their zones, or to zone around students, to enable some to have well-appointed classrooms where education abounds, and others in desperately horrible conditions. We're talking in many instances rat infestations and buildings that are too old, mold and other types of things, not to mention teachers who want to be able to teach but can't, then we need to think about what local control is. And we have standards in law that allow that. The problem is we haven't invested much in exploring them. If we think of local control as analogous to a reasonable decision that a state might make, then we can think of local control as being an empirically challengeable doctrine. It doesn't mean that we should cede all power to local governments because they are proximate to students or proximate to teachers. It does mean that we can think about arbitrariness or capricious behavior differently when involving school districts and individual decisions made by teachers that affect students and families. One of the things that gets in the way of educational justice is an advocacy expectation that the conditions will be what they will be until a family or a student stands up, usually at their own expense, usually to their own detriment. And I think of this, I think of the many families who stood up, who desegregated the nation's public schools. They're the parties who are most often the plaintiffs in school desegregation cases, sometimes the defendants. We don't talk about the struggle and the cost to those individuals for having desegregated. And that's not just for the nation's public K-12 schools, it's also true for the nation's colleges and universities. We expect families to accept what we give them, and we give them very limited means for addressing when they have been wronged, when they are not getting adequate education. We have developed a jurisprudence, that is law for those of you who are not lawyers, that says, well, as long as the aggrieved party can't prove with very definite proof that a school district acted with the intent to harm, then you can't recover. And it doesn't matter how grossly inadequate or how unequal the education is. We've made people fight very hard for scraps, for crumbs. And so this is how we've arrived in the unjust education moment. We have gifted and talented schools that operate in many instances as segregative. We have PhD programs where it is very difficult to find cohorts and complements of students of color. We have women who are often not tracked well, who are not supported. We have students who are valued for their athletics to the detriment of their learning. We have trans students who are not allowed to participate in any sports according to certain states. We have mathematics, calculus, and language classes that prove that we can educate everyone, but we do everything we can to signal and to separate, to make sure that some students have while other students can't. We talk often about advanced placement and international baccalaureate programs, but we've done that to the cost of educating everyone. Graduation requirements are more complex and less rigorous, which seems paradoxical, but it's true. We don't offer meaningful instruction. We don't encourage meaningful instruction. We have a very highly credentialized system where people want the grade and not the learning because that's what we've taught them to want. And these events affect students of color, largely Black students, more than others. At the end of the day, we have created this monster. And I say we, in this instance, including education and law, because while the conversation has not been happening between educators and lawmakers, the on-the-ground experience, the lack of teaching and learning that has happened to a lot of students has continued for decades. We're nearing 50 years of San Antonio versus Rodriguez, the moment where advocates believed that we would actually accomplish a meaningful acknowledgement of what education means. I'd be remiss here if I didn't mention the fact that Rodriguez was brought by Mexican-American plaintiffs. And according to Rachel Moran at UC Irvine, and I tend to agree, that actually had a major influence on the outcome. Had we been talking perhaps about Black students, we might have had a different outcome, but even that is challengeable. If you look at what happened when an attempt was made to accomplish school desegregation across school district lines in Milliken versus Bradley. But it is to say, whether we're talking about the miseducation or the uneducation is not a word, undereducation of students of color, of disabled students, of women, that we've created a system that has such strong inertia, an inertia that is justified by our fetish for local control, that we are not anywhere close to accomplishing education justice, let alone the education justice that the parties in Brown versus Board of Education might have wanted. This means if you can afford an independent school education, and that often comes with its own set of problems, if you can afford to provide testing support that will allow your child to be eligible for certain schools within schools, if you can afford homeschooling, then you might have an option that will allow you to avoid much of this conversation. But if, like the majority of American families, where the only real option is the public school option, our failure to rigorously enforce an equality lens, an equity perspective in how schooling and school opportunities are meted has created a strong imbalance that is going to affect us for decades to come. The question in Swan versus Charlotte Mecklenburg was effectively whether Brown required schools to take affirmative actions to desegregate. What we've come to now is that whatever Brown required expired once we decided that schools were no longer legally segregated. There's no conversation anymore about what practical segregation looks like, or what practical miseducation looks like, or why the law should care about that. My challenge to everyone, if you're not a lawyer to invest politically, but if you are a lawyer to invest within the constitutional doctrines of equal protection and due process in particular, is to say, what's required here? Now that the states have offered, and every state has, now that the states have offered public education, and they've said in their state constitutions and elsewhere how foundational it is to the function of not only the states, but the republic at large. How do we turn this into something where we have demonstrable empirical facts that support adequate, exceptional, transformative education for all students? If we can do this, and I do believe we can, I have some ideas about that, but I'm trying not to share too many over the Zoom before I finish this next article, we might accomplish education justice. And I yield the balance for questions.
Perfect. Thank you so very much, Professor Shaw. I'd like to invite members of the audience to raise their Zoom hands for questions for Professor Shaw. So please feel free.
I don't see any Zoom hands.
So maybe I can kick us off, Professor Shaw.
Yes.
Would you, I mean, you said that you were perhaps not wanting to share some of the solutions that you have, but I was wondering if you could take the opportunity to give us some of your insights on how you would really deal with the monster, as you term it, that we have created over the decades.
Well, I'll share with you what's in a recent article that was accepted. So I argue that we hold the states accountable. The states have made grand gestures and big declarations and statements in their constitutions and elsewhere that say there is a right to education. Well, some states, very few, I think Kentucky is the leader in this, said, all right, this means that we have to provide at least a basic education for every child. In some instances, Florida, for example, talks about, they actually require high quality education. But I think we need to hold Florida to that. Other states like Alabama say this is nice, but the legislature has the ultimate say in what an education is. If we're going to actually mature the promise of education, we need to take the idea that a state constitution is the supreme law of its land, which generally would throw the question back to state supreme courts. but in a way, it creates an expectation. And that's my big argument. It creates an expectation for those of you all who are in economic policy. You know this is coming strong from econ. There is a defensible expectation in a property interest, and that is the basis for moving forward in the federal courts, because we do have law that recognizes property interest is valuable as something that cannot be unilaterally withdrawn, not even by a state legislature.
So I have Ms. Tasia Harris. Tasia, would you like to ask your question?
Yes, thank you, Daniela, and thank you for speaking today. The talk was really informative and engaging, so thank you for that.
Thank you.
My question is about your discussion of local control. I should say I was a teacher in Baltimore City for several years, and I think it's another example of a place where the state legislature can really be punitive towards a school district where otherwise throughout the state, you're not having those issues. So I think I just want to say that that's where this question comes from. But in your discussion about local control and the advocacy expectation, I think it spoke to a lot of the questions that I had when I was teaching, and I still have now, about what the work looks like if not, that advocacy route, because I do realize that it does place an unfair and unrealistic burden on families that are owed that education, as you've explained, that have been put into different state governments. And like, what does that structure look like? Because I don't think that I've seen it, in terms of what it looks like to be consistently holding states accountable rather than reacting or putting the burden on particular families to be advocates for what they deserve.
Okay, so I have a few thoughts about this. When you were talking, my mind went to two things. One was Mark Malauer has a 1993 article that talks about what the advocacy expectation is for families with disabled children. And I'm alternating between students with disabilities and disabled children, the disability first and the people first language, because of the conversation that's happening in the disability community, without taking sides on either. That's why I'm doing this. But Mark Malauer shed a lot of light on what happens under the Individuals with Disabilities Education Act, the only law that gives real teeth to educational expectations through statute. It's great because people can litigate, people can pursue free and appropriate public education in the least restrictive environment. But it's also problematic because they actually have to mount a massive charge with several administrative steps in the foregoing before you can even get past, in many instances, a right to sue, to go forward with litigation that has questionable outcomes. So I think that on the one hand, you want to preserve the individual right of action because you don't want to cede it entirely to institutions. We know with privacy laws, for example, that hasn't proved beneficial. But we also, we might think differently about Lujan, which is a case on standing. Who has standing to sue? Is it something that people generally in the public ought to be able to sue over? We've had a large conversation over the years about what taxpayer standing is, what it isn't, and without necessarily tying it to one's having paid taxes, we might think differently about what it means, what education means for the citizenry, for the body politic. And if education has a value to this broad group of people, and there's empirics that shows that it does, we could think about what standing is in terms of ensuring that everyone has access to education. Of course, there are a lot of problems with this. And the back end with that would be if you can sue to enhance education in some instances, you could probably sue to reallocate education in ways that are harmful in others. So there's a lot of work that could be done. But broadly speaking, we need to think differently about who has the opportunity to pursue litigation, whether we're talking about class actions or multi-party litigation differently than we have, if we're talking about advocacy organizations able to stand and sue because they have an interest. I'm thinking about what an NAACP legal defense fund could be able to do if they didn't have, for example, a lead plaintiff. But it was an excellent question. It is definitely, that's some of the work that we need to be doing in law. And it seems to be the province more of a federal courts class than something that I am very deeply familiar with, but I'm definitely willing to learn in order to bring us across the finish line.
Ms. Barbara Stengel.
Thank you very much, Professor Shaw. How are you?
Hi, Barb.
I'm really fascinated by this notion that we can make legal hay by redefining or carefully and substantively defining education rather than going at some of the other difficult issues. And I definitely want to talk more with you about what that definition of education might be. But can you tell me, for someone who is not a lawyer, how do you see this definition getting into the law, generally speaking? And I don't want you to give away all your thinking, but do you see this as something that will happen through the courts or something that will happen through legislation, or both?
I would say both. So it can either happen through constitutional amendment, which, depending on the jurisdiction, can be voter initiated or is initiated by the legislature. It could be by holding, some of the states have already done it. They've defined it fairly well. The state Supreme Courts are just unwilling to make the legislatures honor it. And in third instances, this is where social science comes in. I don't think that I think social science has not contributed enough to the legal conversation. We can help the courts understand, when you say education, this is what education means to regular people walking on the street. The judge I clerked for, Judge Lewis Sands, always talks about walking people. If it makes sense to walking people, it makes sense to the court. So walking people will think that education means a meaningful opportunity to learn. It does not mean sitting in a room for hours while everything but teaching and learning happens. So there are opportunities for us to do that. Somehow the definition has to be made clear to state Supreme Courts, and if not those, the federal appellate courts.
Ms. Cherise Reyes.
Yes, thank you so much, Professor Shaw. I really enjoyed your presentation this afternoon. Something that you said to me as a mother, but also as an attorney, that really spoke to me, and I was hoping you could expound on a little bit. I believe you said something to the effect of meritocracy is a malignant lie that traps children in testing regimes. So I love to hear your thoughts on what can the states and educational institutions be doing to truly ensure equal access for all students without a reliance or an over-reliance on standardized testing?
So it's a complicated question. I'll try to answer it in 3 parts. If I go to 4, you all, I hope, will indulge me. First, I don't think we should be assigning students to classes based off of tests. It's fairly simple to stop doing that. If students, broadly speaking, can learn, then we give them the opportunity to learn. Research has shown that students do well in differentiated education when that differentiated education is well supported. And I think I probably used that term too opaquely. I mean education where all students of a variety of ability levels are in the same classroom or getting the same instruction, but the instruction is targeted at different points without necessarily identifying the students who are at a particular learning level. So students can engage at the same lesson in whichever ways they need to. They can rely upon peer supports. Often it requires more resources like co-teaching, good co-teaching where teachers are actually invested in and taught how to explain concepts of varying types to learners. It's something that I think I'm trying to do right now, and talking to people who are in law, who are not in law, who are in education, who aren't, trying to make sure that we can all come together to do that. That's the first thing. The second thing is I believe the testing regime was instituted based off of fear. If you are talking about desegregation, for example, and you still believe that some students are going to be harmed by whatever attempted integration the school districts managed, then you're going to want to create different opportunities for kids, and you're going to want to be able to say, this is not about race. And if it's not about race, what should it be about? It should be about ability. So let's just ignore the fact that every test that has been created ever has had some unknown component that is racialized, or some component that we cannot distill away from race, some ability component. We can walk away from that. In some instances, the states have. So I give Georgia a lot of heat, but one of the things the state of Georgia did was to reduce the number of high stakes tests that students were required to survive in order to pass to the next grade level in a particular course or to graduate. We can do that. We can do more of this. And we can also stop investing in testing culture. The reason that, I went to the law school that I went to, and many people went to the law school they went to, is because they paid lots of money to go to Kaplan or Princeton Review or some testing. That's a problem. I mean, and I'm sure if somebody's here on that call, on the Zoom, who is from those companies, they're not going to like this, but this makes no sense because whatever it is we thought we were measuring is actually confounded by the ability to access preparation by wealth. We can withdraw from that. What you can do as a mother. In some states, I believe Georgia is one of them, a parent can insist upon their child's identification and their placement in a gifted or talented class or in an advanced placement class. So irrespective of what a teacher might say, you can say, I would like my child to be placed here. And you need to explain to me why my child won't be placed here. And I will wait until my child is placed there. It is a strategy to go back to advocacy expectation that one shouldn't have to employ. But unfortunately, we do. And I think the democratic opportunity, the just opportunity is to evangelize this approach and say, and make sure that all parents know that they have that same right to ensure that their students get the educations that they deserve.
Wonderful, thank you. Mr. Ramon Ryan.
Hey, Professor Shaw, thank you so much for speaking to us today. So I had a question about, I really appreciated how you put it when you said, you described our fetish for local control. And that has led to the kind of disparate educational standards around the country. So I'm wondering, in kind of like zooming out, do you see the executive branch on the federal level having some role in addressing the issues that you raise, or should we be focused on specifically a legislative or judicial approach to this?
Well, ideally, given the structure of government, a legislative approach would be preferred. Congress is the sovereign in the United States. Without going too much into structure of government, that's always the preferred route. Barring a constitutional amendment, if you can get it through Congress, that's advisable. But even when Congress enacts statutes, they have to be enforced. And so it's going to come back to the courts eventually. So whether it comes to the court as a constitutional question of either due process or equal protection, or somehow an amendment that establishes education as a fundamental right, or as interpretation of a particular statute, we're going to end up at the same place that I began the conversation with, which is the courts need to be able to understand what education is. We have to explain it to the courts, and we are uniquely situated to do that. An executive approach seems less desirable, although there are many instances where it's the only available approach. So I'm thinking of Race to the Top, which was a disaster by all accounts. It was an executive attempt to circumvent Congress in how Congress was either not attending to educational needs or did not think that funding was necessary or could have been diverted in different ways for education. So I'm not saying that executive action is wrong. There are many instances where it has been very helpful, but in the hierarchy of desirable approaches, I would say constitutional amendment, not terribly politically feasible. Legislative action, more politically feasible than I think necessary, but even that comes with the third one, which is judicial interpretation. And fourth one would be executive action.
Thank you. Ms. Kaylee Brillard. Kaylee?
Hi, thank you, Professor Shaw, for this talk. This has been really great. I'm interested in hearing more about your thoughts on the accessibility of higher education and specifically law school. So for me, as a first-gen college student, I feel very strongly that I wouldn't have made it to college, let alone law school, without my white privilege. And I'm just interested in hearing more about how deeply these issues manifest in law school, especially given the cost of hundreds of thousands of dollars. Law school is still being white dominated institutions, and what you already touched on with the testing and admission practices, and what the law school and specifically Vanderbilt's responsibility or role is in all of this?
Y'all, I love a question that asks me to put the institution where I work to task. Genuinely, I love those types of questions. So I'm going to do that. So law school is expensive. Graduate education is expensive. Higher education is expensive, and it is unnecessarily expensive. There are economists of education who could answer how to make it less expensive more easily than I could, but on balance, this is a runaway train. The cost has far exceeded inflation, it's far exceeded salaries, it's not going to catch up anytime soon. For those of us who are in my generation, we were the last generation that was told and almost believed the lie, that whatever the cost of higher education is will make sufficient salary to beat it. And we were hit with not one, but two recessions, one of which is currently ongoing. So this is where the conversation about student debt happens. The following generation was introduced to no loan options for paying for college, which when people took them up were helpful, but that doesn't really get you through law school, or it doesn't get you through graduate school for those who are not attending fully funded programs. One of the adverse consequences has actually befallen the educational environment itself, which is now we believe that students are consumers, they're clients, they're customers, and we don't think of them as learners, to the extent where we're willing to coddle in some instances or not teach in other instances, or grade inflation is outstanding. I mean, if you're paying $80,000 a year, you do not want to see a D. It's just not going to happen. I mean, that's just reality. So that's one part of it. Another part of it is what you talked about, Kaylee, which is how the cost is prohibitive. You have a lot of people who would like to go to schools. You have a lot of people who would like to go to Vanderbilt, who are getting into Vanderbilt and who cannot afford it, or who see the price tag, particularly the student loan price tag, and run away from it. One way that I think we can address this is to take on federal financial aid head on. Why is the federal government making money off of poverty? Why is it? Doesn't make any sense. If the whole point is to facilitate access, then the federal government should definitely enforce collection, but they shouldn't be making sufficient money off of poverty that students are years later owing more, even after having paid on time minimum amounts as prescribed by the government, than they actually borrowed from the government. The government literally is taking advantage of poverty. And poverty in this instance is broad, extending to what many people might consider as middle class, as what many people might consider upper middle class, because the cost of higher education is so prohibitive. Of course, to the extent that wealth is in some instances collinear, but certainly highly associated with race, you're seeing a racialized effect, both in terms of the schools that people can attend and the schools that people can't. One way that Vanderbilt and other institutions could address this is to start directing scholarship funds towards students whom they know are qualified, talented, and who otherwise would not be able to attend. Some of this has happened on the undergraduate side, and I'm sure some of it's happened on the law school side because I've seen it on the graduate school side as well, but more of those efforts need to happen. And in some instances, we need to just be open and honest about saying we have a compelling interest, to borrow from Bakke, in addressing lack of access by virtue of race, and that we're going to do this by programs that recruit students, programs that yield students, programs that help students pay for the cost, and programs that help students get jobs so they will be able to be productive, and then, hopefully it'll come back to us, but not necessarily in terms of giving.
Wonderful.
There are a couple of questions in the chat.
There are. Miss Lillian Wen, would you like to ask your question, or I can read it out for you, whatever you like?
Sure, I can read it. Can you hear me?
Yes, perfectly.
Okay. Thank you, Professor Shaw, for your talk. It was very inspirational and I really enjoyed it. While some institutions have tried to promote acceptance and safe environments for all, there are definitely still distinct divides between students. You can call it de facto segregation or just finding people with common interests or backgrounds, whatever it may be. Many students of color understand that institutionalized injustice exists in access to higher education, even within the classroom. but still these divisions between them can cause more problems. So how would you encourage current university students to combat discrimination and injustice in education with regard to solidarity without competing in these oppression Olympics, as some people call it?
Okay, well, first, the obligation to avoid race or sex or disability discrimination, among others, is in the law, and that obligation falls to the institution. So to the institution, I would say the institution should be doing more. The institution knows that these oppression Olympics happen. They know that they're serving some students better than others. They know they're serving some diverse constituencies better than others. And that needs to stop. Full stop. Secondly, I would say to students that you have more in common than you have difference. And I don't say this in the classic erasure model. What I'm saying is what you have in common is an experience of discrimination. You have an experience of not belonging. You have experiences of the institution failing to fully understand and appreciate you for who you are. This gives you the opportunity to work in solidarity. But that solidarity you can have a mosaic solidarity. It doesn't have to be uniform. It doesn't have to be essentialized. The way that we understand one person's difference can help me understand another person's difference without erasing what those differences are, either between those two individuals or between individuals of varying diversity and the institutional median or mean. That's the first thing. The second thing is we're all learning. And if we actually take learning seriously, then many of the situations, including those that trigger legal responses, can be avoided. What tends to happen is institutions freeze, they fall into a fear conversation, and they don't pursue learning. It is okay for people to make mistakes. What is not okay is for people to haphazardly make mistakes. It is not okay for people to haphazardly ignore who the people they are serving. It is not okay for the institution to not respond when students are being discriminated against in a variety of ways, seen and unseen. It is actually the institution's responsibility to be proactive in identifying and eradicating it, whether it is through the curriculum, through the pedagogy, through the student organizations that are supported, through the funding for any of those things and others. It is the institution's obligation. And I will also say that we need to relieve students of the burden of having to tell us these things, because that is not their job, that is our job as faculty.
Wonderful. Ms. Rachel Anderson, what would you like to read your question or say your question? Rachel, I can read
mute. I was muted.
Wonderful.
Sorry.
Excellent.
Yeah, just thank you. It's lovely to hear from you. So I work at Vanderbilt. I'm a lawyer. I'm headed to Peabody next year as a student. So I think deeply about like what as teachers we're doing and how we're responsive to the needs in front of us and how we contribute to educational equity on the ground. And so I was kind of zooming out when we're talking, and I was wondering when we're talking about accountability, for these little school districts, what's the place for like micro local, like the creativity and wanting to make sure that on the ground who are the teachers, especially of like the K through 12, like they know their community, they know the program help, and they've been so stifled by mandates coming from far away. So I would just love to hear you that, or I don't want to step on any deeper topics, but anything to say would be appreciated.
Thank you for that question. So when I think about smaller school districts in particular, I think of how creative they actually are. So you're talking about a lot of like your very rural districts that people don't talk about, similar to your urban districts that people do, that are trying to find ways to make, lemonade out of oranges or rotten fruit in some instances. What the federal government and the state governments can do a better job of is structuring funding. So to the extent that local governments can articulate what their needs are, they need to have a clear pathway of articulating what their needs are. And this is also an opportunity for social scientists, particularly in education, to support those articulations. If you're saying we cannot get Spanish teachers to this rural county because nobody wants to live here, well, that means you're going to have to incentivize things differently. And since we tend to love economics and law and politics, this is an opportunity for economics to be used for the better good. Maybe we help the school districts make that pitch to the state legislatures. And if the state legislatures are obligated to do what is required to provide that foundational education, that conversation is different. So it's a combination of helping local districts make their way to the state legislatures and lobby, even if they don't have official lobbyists, but having enabled the conversation to be productive through what I like to call the public right to education, which is an articulable, defensible way of understanding what education obligations are, and that they're just not hortatory or suggestive statements, that they have real teeth behind them. So it would not divest local control in the sense that the individual school districts would not know what they need. What I'm advocating for is an educational expectation that's portable. Whether I'm in Clarksville or Nashville, whether I'm in Tennessee or Utah, I should be able to expect and get and thrive in public education.
Thank you so much.
You're welcome.
Wonderful. So Mr. Matthew Schultz.
Hey, good afternoon, Matthew. Good to see you. I sort of following up on what you just said there, I mean, I think a federal law at this point, given the current political climate, seems pretty unlikely. But we do know one thing, one way that the federal government and state government try to control is through federal funding. I mean, our state education system and local education systems wouldn't survive without federal funding or state funding, however you want to look at it. Do you see a path where the administration could potentially say, hey, you are potentially going to lose your funding if your state or your local school district doesn't come up with a basic definition of education, or doesn't provide at a minimum some sort of framework to guarantee education for everybody?
Well, the authority is already there in the Elementary and Secondary Education Act as amended. One of the issues is the Department of Education has been very reluctant to pursue that. That tends to be a multi-year proposition, the idea of you're going to sue a school district for not providing the education that they promised to do in order to accept federal funds. And to accomplish this in any meaningful way, you'd either have to identify those districts that are egregious in not providing education, which would almost require us to ignore the fact that more than fewer districts are. Or you'd have to say, we're going to tackle a state at a time and find a state that is a state where it is not a political disaster to pursue, where the failure is not a function of state revenues being poor, and then and a state where they could actually accomplish the educational objective. I mean, I'm thinking of only one where I think it might work, and that's Texas. I mean, one could sue Texas. Texas does have the money. Texas will fight back. Texas is notorious for fighting back. So the strategy is there. Whether the payoff will happen in any reasonable time frame is a different conversation. One thing that one could do is the Department of Education could announce that it's going to pursue this line. We saw it in Title IX, just the announcement that there will be a different enforcement strategy had an effect on institutions' response in just providing Title IX services or advocacy, or even structuring how people might file Title IX complaints and grievances. So whether we actually accomplish it through lawsuits, or we accomplish it through enforcement, or we accomplish it through announcing the enforcement, there is a pathway. And I thank you also for allowing me to say that the primary way the federal government influences public education is through funding, and it's legislative.
Wonderful, and we're on the hour. So I'd like to encourage all of us to come together to thank Professor Matthew Shaw for that incredible, powerful, inspiring, completely insightful talk over the hour, and for giving us such an opportunity to discuss it. So thank you so much, Professor Shaw, for helping us round out our Dean's Lecture Series. It has been a wonderful experience to hear from these scholars in Vanderbilt to enrich our understanding of the current context and to get such a variety of ideas to our community. Most of all, thank you all so much for coming today. For the lecture series, I'd like to thank Dean Pristurkin, Kara Cruz Street, Bernadette Pascal Graffried, Jake Kasinger and Brandy Drinnen for everything they've done to make this happen. And thank you all so very, very much for participating. It's been wonderful. So thank you all so much.
Thank you all for having me.